The 60s and 70s have brought about life-changing legislation for those with disabilities. Many look at the admission of Ed Roberts to the University of California at Berkeley in 1962 as a pivotal moment in the history of the disability movement. He was a quadriplegic, paralyzed from the neck down due to childhood polio, and overcame opposition to achieve admission to Berkeley. He won a lawsuit that allowed him to be housed in the campus hospital and being able to attend classes. He had an 800-pound iron lung. Soon, a group of men and women with disabilities joined Roberts on campus, and they dubbed themselves the Rolling Quads. They banded together to fight for better services and the right to live independently. With a grant from the U.S. Office of Education, they started the Physically Disabled Students Group, the first of its kind on any college campus, and really, it was effectively the start of the independent living movement. He had this most feisty mom, remember the power and the belief of parents, who fought for him to attend school by telephone for 3 years when he was growing up. Many of you are likely familiar with the Civil Rights Act of 1964, which raised the consciousness of unequal treatment of certain groups in the U.S. Another reason this is part of the disability history timeline we're putting together is that the non-discriminatory language used in the Civil Rights Act was directly taken and put into the Section 504 Rehabilitation Act of 1973. The language was copied straight out of the Civil Rights Bill into Section 504. Here is its version right now. No otherwise qualified individual with a disability in the United States shall solely by reason of her or his disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So in 1973, this Rehabilitation Act was passed by Congress. Many thought it was just a spending bill, over $1.55 billion to be spent on the disabled. But what few also realize is that it made it illegal for these agencies to discriminate against anyone solely by reason of, at that time, handicap was the term they used. So really, it was the first anti-discrimination law for those with disabilities, but it was just about access, and there was no teeth other than federal funding would be withheld if access wasn't given. However, the Department of Health, Education, and Welfare stalled under Ford's administration as they had written this 105 pages of regulations that hadn't been approved. If a law isn't regulated, then it can't go into effect. Several years passed, and the American Coalition of Citizens with Disabilities organized to create the longest national sit-in in U.S. history. It lasted 25 days. People with disabilities occupied regional HUE offices across the nation, from San Francisco to Washington, D.C. Panthers were bringing in portable showers. Information was being signed in ASL out of the buildings to reporters, and they couldn't be removed because they didn't have accessible transportation or jails. It was quite the demonstration. Judy Heumann, one of the Dynamo leaders who later would become the Assistant Secretary for Special Education and Rehabilitative Services, and Frank Bowie, demonstrated outside Joseph Califano's home. He was the new Health, Education, and Welfare Secretary, to force him to rewrite the regulations that had been watered down. His dog attacked her on the front porch. The media went berserk with pictures across the nation. Califano had no idea what Section 504 was. He hadn't been briefed by Washington. If you want to hear actual footage and audio from the sit-in, Bethel has the NPR audio CDs of the Disability History Project, An Overdue Revolution. It was such a success because they proved the point that nothing was accessible. In 1975, the Education of All Handicapped Child Act was passed to provide a free and appropriate public education to students with disabilities. At this point, children with disabilities couldn't go to schools. But after the passage of this act, this was now a possibility. The name of this act has been changed as it's been reauthorized and amended over time. It's now entitled the Individuals with Disabilities Act. It was amended in 1990 and then reauthorized in 1997 and 2004. More importantly, it provides for non-discriminatory and multidisciplinary assessments. The assessments must be in the child's native language, and the norm samples of the tests used should include those children's ethnicities. Different professionals from different disciplines give assessments. Usually a school psych will give an IQ and a social emotional assessments that look at attention disorders, learning disabilities, mental health issues such as anxiety and depression, and developmental disabilities. A special education teacher generally gives an achievement test to check for knowledge gain through schooling experiences. An occupational therapist or an OT may do assessment of fine and gross motor abilities that impact school achievement. A school nurse will do health and medical screening, such as vision, hearing, or any other medical issues like ADHD that might be getting in the way of learning. Parents also have a right to give permission for assessment and to accept or deny special education services for their child. If the student meets criteria for special ed services, then they will have what is called an individualized education plan that documents their current levels of performance and goals to work toward, as well as services and intervention strategies needed to progress. These are annually reviewed, and the school personnel should document significant progress, or the IEP needs to be rewritten, different interventions implemented, or more assessment work may be needed. The fourth main provision of IDEA is that the student should be serviced in the least restrictive environment that meets their needs. This is generally the student's local community school, but sometimes their needs need to be serviced in another setting to provide the depth of supportive services. Special ed isn't a place. It's really a set of services which should always be based on needs. Justin Dart was a wheelchair user from polio, and he visited every state inquiring about the state of those with disabilities. He was one of the authors of the Americans with Disabilities Act. He began his work as a chair of the Texas government William Clement's Task Force for Long-Range Policy for People with Disabilities. He took a trip to South Vietnam, where those with disabilities, just like himself, they were polio survivors, were taken to this metal shed with a concrete floor and left to die. He actually witnessed 100 young children with polio brought there to die. One of the other key authors of the ADA was Robert Bergdorf. He was a disability rights lawyer, and he saw the need for a civil rights law. One of the other writers was Patricia Wright, who actually was a personal attendant to Judy Heumann for 2 years. Many senators and representatives understood the stigma of a disability, or they had a family member with a disability. Ed Kennedy, one of the writers of the bill, had a son who lost his leg to cancer. Senator Harkin delivered part of his speech in sign language so his deaf brother could understand. Bob Dole had injuries from the war. Orrin Hatch had a brother-in-law who had an iron lung similar to Ed Roberts. Representative Kolo was diagnosed with epilepsy. President George Bush had a 3-year-old daughter die from leukemia. His son Neil had a severe learning disability, and Marvin, his youngest son, had a section of his colon removed, had a plasticostomy bag. So among these legislators, there existed this hidden army of support. Small businesses were opposed and against the passage of the legislation, and restaurant associations and public transportation communities, of course, were opposed. Others worried about the cost of work-related accommodations. But a recent study has shown that these accommodations, half of them cost little or nothing, while another 30% cost somewhere between $100 and $500. The bill passed the Senate 76-8 and the House 377-28 with strong majorities in both. ADA was the most significant law which gave protections to people with disabilities that were the same as those provided to people on the basis of race, sex, national origin, and religion. The Americans with Disabilities Act has 5 titles that cover access. Title I is employment. No employer with 15 or more employees can discriminate against an individual with a disability who is qualified and capable of performing what are the essential functions of the job. Further, employers must provide reasonable accommodations, which include adapting employment testing procedures, providing assistive technology, restructuring job schedules, providing written materials in alternate formats such as Braille, providing sign language interpreters, time off for visits to therapists, and architectural access for employees with disabilities. And employers can't ask about disabilities. They can require a pre-employment medical examination only after a conditional offer of employment has been made. And employers must pay employees with disabilities at the same rates as comparable employees without disabilities, which extends to benefits, including health insurance. However, the loophole is private clubs, organizations, and churches and Native American tribes. They're exempt from this title. In the Title II of transportation, accessible vehicles needed to be provided of comparable level and comparable response time as vehicles used for people without disabilities. Recently, Uber was making changes to provide more accessible options of cars for those with disabilities under some of this title legislation. Public accommodations and services include like hotels and restaurants, theaters, art galleries, libraries, shopping malls, banks, professional offices, recreational facilities, parks, and zoos. Telecommunications, Title IV, provided that individuals with speech and hearing disabilities have a right to rapid, efficient, nationwide telephone and telecommunication systems at no cost to the user, especially in the case of emergencies. Email, website, and databases have to be in alternative formats for individuals who are blind or who have learning disabilities. And the fifth title, the last one, is kind of a potpourri, miscellaneous title, but it does include guidelines for making historical sites and wildernesses accessible to people with disabilities. In 2008, another key point on your timeline, ADA amendments were expanded to include if someone was discriminated against due to a perceived disability, whether there actually is one or not. So we've traveled the path that led to civil rights legislation for people with disabilities. We've seen ugly, inhumane treatment and beautiful, ingenious activism in their history. I want to leave you with a next step forward in our own state's history and treatment of people with disabilities. When individuals with disabilities were at Minnesota institutions, such as those at Faribault, they were buried with unmarked graves, not even respected enough to put their name with them. Currently, a group is taking the time and raising funds to provide grave markers with their precious names. Each life is inherently valuable and reflects the image of God and contributes to the diversity of humanity.